Okay, in this video I'm going to take a look at replies to particulars. What are replies to particulars? What are notices to particulars? You may come across this if you're involved in any sort of litigation. So let's take a look now. So replies to particulars, they occur, as I say, in civil litigation. If you're involved in a litigation in Irish law, well then you probably will face a notice for particulars and you must do replies to particulars. Particulars are essentially details. So litigation, just to recap, is the process that you engage in when you're involved in civil legal proceedings. For example, in a personal injury claim or a commercial dispute. That's examples of litigation. An important part of it is serving a notice for particulars and the consequent replies to the notice for particulars. So the notice for particulars is essentially a series of questions that the defendant will send to the plaintiff in order to see what case he'll have to meet and to ascertain the details of the alleged wrongdoing, the circumstances giving rise to the claim, and details of the injury or damage suffered, and so on. It forces the plaintiff to set out the exact details of his claim, and the defendant then obviously will be able to understand what claim he has to meet. The formal legal position of the parties is set out in the pleadings, and the pleadings combined with the particulars allows a party to the proceedings to see in broad outline the case that he will have to meet at trial. In recent years, however, there has been some developments in the whole area of particulars, and that is in seeking too extensive and too broad and sometimes too oppressive particulars. And these situations have been considered by courts because invariably the defendant or defendant solicitor won't reply to them, will only reply to some of the particulars, some of the questions raised. Section 11 of the Civil Liability in Courts Act of 2004 allows the defendant in a personal injury action to seek particular details, particulars as it were. So you see the four headings there on the screen: particulars of any personal injuries action brought by the plaintiff in which a court made an award of damages. So this is any previous claims. Particulars of any personal injuries brought by the plaintiff which was withdrawn or settled, and this again covers previous claims. Particulars of any injury sustained or treatment administered to the plaintiff that would have a bearing on the personal injuries to which the personal injuries action relates. So essentially, if you're complaining about a bad back or have brought a claim in respect of an injury to your back, you're being asked here to set out any details of previous injuries to your back, because it may be the re-agitation, as it were, of a pre-existing injury. And then the name of any persons from whom the plaintiff received medical treatment. These are basic particulars that the Section 11 of the Civil Liability in Courts Act 2004 allowed the defendant to seek. There was a decision there though in 2013 or thereabouts, in this case Armstrong versus Moffat. It's a High Court case. Two of the defendants in this case sought particulars of information over and above what was provided for in Section 11, and the plaintiff's solicitor then refused the request and pointed to Section 11 and said this was the extent of his client's obligations, and the High Court then was asked to determine the issue. The High Court held that the particulars shall be ordered if it is just to do so, that is, in the interest of fair procedures, and to ensure a party will not be taken by surprise by the case he has to meet at trial. However, the Judge Hogan, he went on to say that the courts should be more prepared to refuse requests for particulars that are oppressive and indiscriminate, and possibly an abuse of process. He also referred to the fact that the Oireachtas had set out in Section 10 of the Civil Liability in Courts Act 2004 how a personal injuries claim should be pleaded, and if this was done correctly, the need for further extensive replies to particulars should be the exception and not the rule. He struck out particulars which fell outside of Section 11 in this particular case. He also commented that even though the indiscriminate use of excessive particulars was curtailed by the Act in respect of personal injury claims, there was no break put on such requests in other types of case, in other words, non-personal injury cases. In conclusion, notices for particulars should be used to establish in broad outline the case the defendant has to meet at trial, Anything over and above this should be carefully considered by both parties, because there's a risk of such requests being struck down by the High Court with consequent costs implications arising from the dispute about what is to be answered and what's not to be answered. As the Judge Hogan, said in this particular case, Armstrong and Moffat, in this, as in much else in litigation, the fox is more likely to prevail than the lion. In other words, you do need to be strategic and intentional about the questions that you ask and not use a broad shotgun approach. I hope you find this video useful. If you do, give it a thumbs up down below, and you may be interested in subscribing to my YouTube channel. My contact details are on the screen there, and as I say, if you think it's useful or any way beneficial to you, give it a thumbs up down below. Thank you.